Let's start. This appeal has been preferred by Sadhana Choudhury, being aggrieved against an order dated 12/12/2018 passed by the High Court of Judicature at Allahabad, by which her writ petition seeking judicial review of her dismissal from the Uttar Pradesh Higher Judicial Services by respondent number 1 had been rejected. The appellant was recruited into the Uttar Pradesh Judicial Services on 05/06/1975 and was posted as additional Munship Dehradun. She was subsequently promoted to the Chief Judicial Magistrate cadre in 1981 and again to the Uttar Pradesh Higher Judicial Services on 21/03/1987, a division bench of the High Court of Judicature at Allahabad, while seized of the first appeal against a land acquisition reference, made certain observations on 05/03/2004 with regard to the manner in which some other land acquisition cases of similar nature were being adjudicated by subordinate judicial officers in the state of Uttar Pradesh. A copy of the judgment was placed by the registrar before the Administrative Committee of High Court for appropriate action. The Administrative Committee constituted a committee comprising of 2 judges to probe into complaints of collusion in land acquisition matters. This inquiry committee, after visiting numerous districts of Western Uttar Pradesh (UP) and examination of many judgments, submitted a report on 1909/2004 recommending initiation of disciplinary action against certain judicial officers, including the appellant. Accordingly, a charge sheet was served upon the appellant with regard to judicial orders delivered by her during her stint as additional district judge at Ghaziabad, following were the charges attributed to the appellant. The appellant submitted detailed reply to the charge sheet as well as additional written arguments. Subsequently, an inquiry was conducted and the inquiry committee, through its report dated 09/09/2005, held that both the charges had been proved, for these were errors apparent in both cases, which were such shocking blunders that they could not be attributed to mere misjudgment and consequently were proved to be deliberate. The said report was placed before the Administrative Committee, which accepted the same by the resolution dated 29/11/2005 and referred the matter to the full court for determination of quantum of punishment. The full court resolved to dismiss the appellant from service and consequently forwarded its recommendation to the state (respondent number 1), which through an office memorandum issued by its appointments department on 17/01/2006 dismissed the appellant from service with immediate effect. The appellant challenged the order of dismissal before the High Court on judicial side, invoking the writ jurisdiction. The division bench of the High Court took note of the 2 land acquisition references which had been decided by the appellant with regard to the first case of Lily Singh versus State. It held that the appellant had wrongly relied upon a compromise deed of 2 other claimants to enhance compensation from rupees 74.40 per square yard (as determined by the Special Land Acquisition Officer to rupees 264 per square yard. Additionally, she had awarded solatium and interest over and above the said determined rate, which led to a steep escalation to rupees 720 per square yard, holding such reliance on compromise deeds as being comprehensible owing to the statutory bar of Section 11 (3) of the Land Acquisition Act 1894. The escalation was deemed disproportionate and against judicial propriety. Stop. Thank you.